All right, let's go ahead and do this. It's after 2. Thank you for showing up. Just first, a bit of a disclaimer. As usual, presentations have had a couple technical difficulties here. So what you're seeing is more or less exactly what I intended to present. What's happening on my screen is something entirely different. So I do basically have my slides here for notes, because I can't necessarily see that going on. But there's see me flipping through some paper. That's what's going on. Secondly, I would say that the initial presenter was going to be Trey Ford, one of my colleagues at Rapid7. He's going to be basically giving a similar talk with a slightly different title. So if you came here wishing to see Trey, he is one of the pair, not going to be here. I'm here instead. But basically the intent of the talk is still the same. So the name of my talk now is Trial by Research, Security Research versus the Law.
How much notice did you get?
Not enough. No, I mean, a couple people heard that I kind of just filled in for Trey, and in all honesty, I'm honored to be here and present this stuff. Because it's I am going to talk about the law, but at the same time, I'm absolutely not a lawyer. I'm a geek at the end of the day, so like me getting up here talking about research and law, I actually enjoy it quite a bit. So just a quick introduction. Who am I? Again, I'm Jon Hart. I'm currently employed by Rapid7. I've been doing security for 15 years now. It's been quite a long journey. I've done everything from really low-level, hardcore research, in a dark room with a dimly lit monitor style research. I've also done quite a bit of policy development and enforcement. Most recently at Rapid7, I was with the product team. I worked on Nexpose, it's our vulnerability management solution. So I was responsible for writing all the vulnerability checks, signatures, all that stuff that our customers use and love. Now I have the honor of being on the Rapid7 Labs team, which I'll talk about in just a couple minutes. And as if this wasn't obvious enough already, I'm absolutely not a lawyer. I'm not wearing a suit like the TAs over there. Even if I was, I don't know if I'd be wearing a suit. So let's talk a bit about Rapid7 Labs. And when I was putting this presentation together, I felt a little bit bad, kind of like bragging about what we do, but at the same time, there's a reason I'm going to talk about what my team does. So Rapid7 Labs, we've been around for about 2 years. It's a cross-functional team led by H.D. Moore. He made this little thing called Metasploit, you may have heard of it. This team is a relatively small team, cross-functional, and by that I mean we have kind of a mix of like DevOps-y type people, researchers like myself, people who are good with media, programmers, and just a whole bunch of a good group of people. We are dedicated entirely to security research, and Rapid7 is a security company. That's what we do. But we don't really focus on any one thing in particular. We don't like go after malware. We don't go to do research on browsing and stuff like that. We really just focus on anything that's new, interesting, or otherwise that has a big impact that can potentially impact large portions of the population or the world. You've probably heard of many groups like Rapid7 Labs. A lot of the big companies, Twitter, Amazon, Google, all those guys tend to have a group of experts. Their day-to-day responsibility is research, kind of making the world a better place from a security perspective. So this is the font is a little small here. Your technical difficulties, like I was mentioning before. But what are some of the things that Rapid7 Labs has done? These are just a quick highlight. But probably our biggest thing we do is a thing called Project Sonar. If you haven't heard of it, Project Sonar started off as something called SSL Sonar, and at its core, it scans the entire public IPv4 internet, collects SSL certificates, and does analysis on the metadata. Expiration dates on certs, who's trusted by who is not trusted, stuff like that. We in turn took that and turned it into something not just for SSL certificates, instead of just scanning the entire public internet minus companies that opt out. Looking for things, common misconfigurations, common vulnerabilities. When I say misconfigurations and vulnerabilities, you're probably saying, oh, you're out there scanning, breaking into systems. Not necessarily. We're out there just kind of doing innocuous, like typically single packet probes, just trying to glean some information from the systems. We also had something called Browser Scan, which went end of life this past summer. Browser Scan was meant to fill a need in the market where your mom, your dad, your grandmother have running Windows XP with a browser that hasn't been updated in years, and you want to figure out how out of date are they of all the plugins. So Browser Scan was there to fill that need and tell you you're running this browser, you have 16 different plugins that have never been updated. Here are all the risks. Browser Scan was end of life because of actually a lot of the stuff that we were doing doing in browser scan. Now the browsers themselves are starting to do so in Chrome and Firefox now. I don't know about Internet Explorer, so someone can correct me if I'm wrong. All of that functionality is built into the browser. So you want to say, go tell me if Adobe Flash or Java, are those things up to date? If not, go update them for me. All that stuff is built into browsers now. Back in 2013, HD and a number of other folks, I don't have the link to the UPnP thing, but if you've heard of HD and some of the work we do, this probably rings a bell. So UPnP is universal plug and play. He found that, I forget the exact number, but on the order of millions, like 8 million or 10 million systems out on the internet, UPnP exposed. UPnP is a very useful service. We probably all use it without even knowing every single day, but has massive security risk. So in addition to just that being exposed on the internet is a really bad thing, he found a lot of number of zero-day vulnerabilities and that did responsible disclosure, notified the parties, all that good stuff. NTP, this one's kind of near to my heart. So I'm going to mention the CVE number off the top of my head because the audience is relatively small. This probably is not going to go over so well, but I'm going to do it anyways. CVE 2013-5211, does that ring a bell with anyone? Didn't, so probably not enough people in this room for that. Okay, Brian, thank you. So that particular CVE is a vulnerability in NTP. It's a traffic amplification vulnerability. So traffic amplification vulnerability is where the amount of packets or data that I, as a user or as a client send a particular server, is vastly outweighed by the number or size of packets that come back. So that particular CVE in December or so of last year was announced, and in turn, the bad guys took that vulnerability and launched some of the biggest denial of service attacks that the internet has ever seen. Something like 300 gigabits a second. That will crush just about anything on the internet. So this past summer, we were doing some scanning for NTP, just kind of seeing are there systems out there still vulnerable to this. And I started seeing a lot of really strange responses, and I said, this doesn't make sense. This feels like there's more to it here. I'm a very curious guy. When I see something that doesn't seem right, I'm going to dig into it more. So I went and dug into NTP more, and I found that exact same vulnerability that came out last December, there's another one that's basically 100% identical to it that still exists in NTP. No one knows about those things. So I went through NTP exhaustively and found all these traffic amplification vulnerabilities, did the disclosure process. Unfortunately, the NTP organization is not going to fix them because they're basically like putting the onus on the user, saying you should be configuring your NTP server correctly. But I felt like I did my part as a researcher. I have dollar protocol because there's something that I'm working on right now that's pretty big. I can't tell you exactly what it is. That's why I have it just hit like that. But it's probably something that's present on everyone's home network that when misconfigured, and unfortunately this thing is misconfigured on a pretty regular basis, that allows someone, a malicious attacker from the outside, to be able to intercept traffic on the inside of your network. One packet of authentication. Pretty big stuff.
So will we have more information on that?
Eventually, yeah. Doing the responsible disclosure reps right now.
Are you getting to the libraries for that then?
What's that?
Is it getting to the right library developers for that?
Yeah, in this particular case, it's much more difficult. It's not just one. It's not just one vendor. It's hundreds. So a lot of the stuff you're hearing me say, if there were lawyers in the room, they'd probably be saying, "Oh, I can't believe he's getting up here talking about scanning the internet and vulnerabilities. That's really dangerous." But the reason I'm allowed to do this is because Rapid7 is a great company to work for. I'm lucky to be there, but we also have lawyers on staff that are trained and understand this sort of stuff. They understand the value of security research and understand the laws that we kind of bump up against on a regular basis. And they're there to make sure we stay in line, but also inevitably when people come knocking at our door wanting to sue us for various things that we've done, that they can defend us. Ignore the wording that another one of my fun technical difficulties. Ignore the wording. I don't know why that happened. But this is probably obvious. The stuff we'll be talking about here is absolutely not legal advice. If you think you can come into this talk here and listen to what I have to say and come out and be an expert and then go scan the internet and you're fine, you're not going to. You might as well cut this thing out and put it in your wallet before you ultimately get the best of it. So what am I going to be talking about today? So at a high level, if I was to take a survey of this room and the next room because there's more people there, most people would probably say that security research is beneficial. I don't really know if anyone has any negative, anything negative to say about security research. I'd love to hear it. I'd love to hear your perspective. So I'm going to be talking about the legal issues as it relates to security research and how it's really hindering things, and present a possible safe path forward. So what do I mean by security research? I don't really just mean me back in my college days in the dark room where everybody, I don't really mean just that sort of stuff. I mean really everything, kind of this the whole security knowledge base from independent researchers doing their research to vendors disclosing the fact that they have vulnerabilities, or corporations disclosing the fact that they've been compromised and how they've been compromised. So really the whole security ecosystem, all the knowledge that exists out there. So who the participants that I'm focusing on this talk are that really participate in the larger security research realm. There's really 5. There could potentially be more, but these are the high levels. There's the vendors, so a company like Cisco or Amazon or eBay, but I don't necessarily mean like a commercial entity, someone that builds a product that sells it for money. It could be Joe Random GitHub project or something in SourceForge. It could be really anything. There's the consumers, so people who use these products, maybe pay for it, maybe not. So researchers like myself. There's the criminals out there that are doing the bad things, trying to subvert security, violate copyright, breaking the systems, obtaining credit card data. And then there's the legal entities that exist that attempt to keep us all in line. So what actually keeps us in line? And this is, I have a couple of acronym soup up here. These are by no means an exhaustive list, and I'm absolutely not an expert in these. So these are just some of the things that attempt to keep us in line, keep all of us in line when it comes to security research. There's PCI DSS, from the payment card side of things. There's HIPAA from a healthcare perspective, and then there's the actual laws, the ones that can land you in the big house, in real time. CFA, DMCA, BsidesLA, and I'm going to go into some of these. So PCI DSS, just a quick show of hands. Anyone in the room ever been through a PCI audit before? I'm sorry. Has anyone ever done a PCI audit before?
I'm a PCI SA, so.
Just raise your hand all the time. So I've been on both. I've been on both sides of the house. I worked for a middleman and payment processor for a while, so I've been through PCI audits, and now Rapid7 PCI is the ASV partner. So technically, we are allowed to certify companies for PCI compliance, and our product is used to do that. So I've kind of seen both sides of things. But anyone that's been through a PCI audit, on either side, probably realizes that PCI is really just like the bare minimum. It's almost like a set of best practices. Like, you're kidding me, like I really have to encrypt credit card data? Like that should be obvious. I shouldn't have to write that down and put in the document that you have to pay money to read. So it's really just, you absolutely should be doing that stuff, but it should be much higher than that. The penalties are pretty severe. There's much more detail to it than this, but the penalties for screwing up with Visa is on the order of $100 grand per month. MasterCard does it differently. It's on a per violation basis. It's up to $200,000 per violation. And if inevitably when this results in a compromise, it's about $50 to $90 per card holder that's compromised. So you can see how it will reach like at Home Depot or Target. In addition to getting these big lump sum fines, you take all the cards that are compromised, and that adds up very quickly. So HIPAA. This should be fairly straightforward. HIPAA is designed. I actually initially thought HIPAA was designed to protect PII, so personally identifiable information. But I learned about this new acronym called PHI, Personal Health Information. Pretty sure that's what that stands for. Very much like PCI, this kind of smells like a set of best practices. But if you read some of the HIPAA documentation, it's even more vague. It's about at about the same level that PCI is, but it's even less prescriptive. It kind of doesn't really talk necessarily about the types of technical controls, but talks about it at a very high level. But this one, very heavy hitting, with $1.5 million in fines if you screw this up. So now let's go ahead and talk about some of the laws. So the laws that really attempt to keep the bad guys in line and that could potentially impact me as a researcher. So again, I mentioned this at the beginning, but these are, one, I'm not listing all the laws that are relevant. Two, I'm not going into like a lot of depth. And three, I wouldn't be surprised if I got something wrong in my slides or going to speak something incorrectly here today, so please forgive me. So CFAA is the Computer Fraud and Abuse Act. I consider this to be like the real big one, the one you really got to be careful of. So I'm gonna look at the screen while I do this because I simply can't memorize these. And so these are basically, I summarized some of the things in CFAA that I kind of find that I feel like they're the big points, but in addition to being the big points, they're also like, me as a technical guy, I read them and I say, this is really a law, this doesn't really make sense. So intentionally accessing a computer without authorization, obtaining information from any protected computer, knowingly causing the transmission of a program, information, code, or command that intentionally causes damage, and knowingly and with intent to defraud traffics into any password or similar information. So does anyone have any comments on some of the things here? Like, what are the sorts of holes you can start poking in these?
It's intentionally vague to the point it's being abused to, I mean, it was originally intended for, financial and government websites. The problem is that, as a defensive security person, someone who comes in and attacks my cloud, technically could be violating the CFAA, and it gets into that fine line of, was their intention to help me find vulnerabilities or to take out my cloud?
Yeah, exactly. So the wording here, intentionally protected, knowingly, intentionally again, password is similar information. So Brian is correct. I swear Brian is in the plant. I've worked with Brian in the past. These laws were originally written to protect government computers and systems that traffic in financial information. That's what they were originally designed for. So more about the CFA. This is a real big hitter. The punishment really quickly jumps to a felony if there's any intent to profit, or if they can prove that there was an intent to profit. If the information obtained was over a certain dollar amount, for example. If you're trying to do something else that is also legal and this has a repeat offense. I mean, you're probably familiar with these sorts of things. That, if the government finds you doing one thing and you're also trying to do another, they're going to hit you repeatedly and you're going to go to jail for a long time. Basically, pretty hefty fines. There can also be civil penalties in addition to or in place of any federal charges if those are thrown out for any reason. Basically, if you can prove that someone violated the CFAA and it was thrown out in federal court, you can sue them if you can prove the damages were over $5,000. I put loss in air quotes. It's like, how do you place a value on like data that's stolen? It's not like a physical good, like my laptop that's worth $2,000. Someone stealing email addresses or credit cards. How do you put a value on something like that? Apologize for the font. These are more of my interesting technical problems. The DMCA. So when I started this talk, I said, "Oh, DMCA. That's the thing that protects DVDs, right?" It's more than this. It's much more than that. It's all about protecting copyrighted things that are meant to be copyrighted. So basically, the two highlights from the DMCA, it is illegal to attempt to bypass any technological measure meant to protect copyright. And similarly, if you traffic in anything that's used to bypass copyright, like a cracker or something like that, and stuff to bypass encryption or encoding in a DVD, for example, that is also illegal. So there are exceptions, and when I was doing my research for this talk, I said, "Oh, cool, there's exceptions." And I saw all these words like reverse engineering, encryption research, security testing. Oh, I'm all set. I can bypass copyright all day long. No, that's absolutely not the case. You read the law, and you read the law, and you're attempting to understand it. And there's exceptions with these exceptions, and all I can really say is if you're going to be doing anything that skirts copyright, don't just read the law. You absolutely have to get a lawyer. That's all I can say. Is just because you think you're doing security testing or security research, simply having authorization from the party that you happen to be working with is probably not enough. Get a lawyer. DMCA, again, with the tough penalties, there can be civil injunctions, the damages, things can pile up and triple. The criminal fines are $500 grand, and they double them for repeat offenses, can even be to $1 million. Kind of wish I had sound here. ECPA, so the Electronic Communications and Privacy Act. If I remember correctly, this was originally written in 1968 and then subsequently updated in '86 to start. Because think about what existed back in 1968 in terms of electronic stuff that you want to protect. you're probably talking about phones and that one guy that had a computer in his house. That's really about it. So Actbug came along in 1986 and updated the original one from 1968 and made it more applicable to things that were starting to happen in 1986. The internet started to become a thing back then. Things were coming online. So Actbug is really a 3-for-1 deal. There's kind of 3 subsections. There actually may be more, but I'm just going to cover these particular 3. So again, Actbug is meant to protect communication. So if you think about, let's just use email, because I find that easier to talk about rather than a phone. Think about the state transitions that an email goes through. So there's the, I'm sitting on my laptop, I'm typing up an email, and that email is shot over the ether, it's floating bits in the air, and eventually it lands. So there's the transmission of that email in the first place. There's it landing on, for example, I send email to someone in the crowd here, it lands on your computer, and then there's also the record of that email being sent by your provider, for example. So these 3 laws are meant to protect your communications as they exist in various states throughout your lifetime. And I go into a little bit of depth in each of these. So the Wiretap Act is meant to protect information on the wire or the air, as the case may be. The Stored Communications Act, or SCA, is meant to protect communications as they're stored. For example, this probably pertains to voicemail, but email is just easier for me to describe. So like when you send an email and it's sitting on a server, the SCA is meant to protect that particular email as it's stored on disk. And then there's something called the pen register tap and trace, and we'll talk about that. So the ECPA, the Wiretap Act, as I started to talk about earlier, this prohibits the interception of any electronic communication where privacy was expected. If you read more into the law, I believe it actually says prohibits the interception of any communication not meant to be public. That's kind of the other way they word it. This one's a felony. 5 years in the big house plus fines if you violate this, and there might be repeat offenses, I'm not sure. There can also be fines, $100 per person per day, or $10,000 per person. Otherwise, one of the big cases, I don't know the exact dates, so someone already knows Jaffe versus Google. Is anyone familiar with that case?
Remember the date, but that was the wireless access point one?
Yeah, so has anyone ever seen those Google cars from Google going around, driving around the streets, mapping stuff? Well, when they first did that, they were also, I don't know when they first did it, but at one point in time, while these cars were driving around the streets and taking pictures and calculating routes, they're also looking for wireless networks. They're also looking for basically any wireless information they could glean from the stuff that's just floating around in the air. Like looking for like access point names that they can detect what sort of security, WPA, WPA2, stuff like that. Just basically metadata about what's out there floating in the air. Google was brought to court. And what ended up happening is Google was found guilty. And this really, I heard about this when it first came out years ago, and just kind of roll off the back. I didn't really think about it much. But then when I read about Actbug and the Wiretap Act and I reread the law, I was kind of dumbfounded that they were found guilty of this. It just doesn't really make sense to me. So the reason they were found guilty is because the court ruled that the general public doesn't have the knowledge to know how to sniff this stuff out of the air. Okay, is that true? Does my grandmother know how to fire a Wireshark? No, she doesn't. But probably anyone in this room knows how to do that. And if they didn't, they have this thing called Google. Very easy to do, very easy to learn how to do this stuff. But Google was found guilty, and I assume they were probably fined. I don't know how severe the fine was, but they were found guilty.
Wasn't part of the problem, though, that they connected to open wireless networks and captured traffic? Sniffed everywhere. So they're not just collecting access point names, but actually connecting to the networks and collecting the data.
Sniffing open air networks.
So that sounds plausible for sure. I would be surprised. I mean, it does change my opinion slightly because that's even more shady than what they were doing before. But yeah. At the same time, so on one hand,
they weren't connecting; they were just doing full packet capture.
Yes, they're capturing unencrypted networks and the passwords are going across.
Well, right. Well, there's so much stupid. How much? How people choose that?
Yeah, but the point is that it's you know, security people understand that, right? But you know, your mother-in-law setting up a wireless web, they can even do it, isn't sitting there going, do I use web or WP?
Oh, no, I'm just worried that because they didn't connect, I mean, like, if they connected, it'd be more egregious, right? Like, the fact that they didn't connect, they literally just left, and it's the default mode, Kismet will do full packet capture, not the way they were using, which was stupid. They should have set the flag and tell them to grab packets.
I don't know, I think that's kind of splitting hairs to say it was okay to do packet capture of open networks and play dumb on that.
Well, I'm not saying it's okay, but it's,
Is it illegal? It's like I was saying, I think everyone in here could probably agree that what they were doing was a little bit shady and potentially illegal. But the fact that the court ruled against Google because the general public doesn't know how to do this seems very strange to me, especially as a researcher who's very technically minded. So how about the Stored Communications Act? Again, this protects information as it's being stored. This is a misdemeanor. Again, if you're doing this repeatedly, you're probably going to go to jail even more. Or if you're doing it for commercial gain, very similar to a lot of the other laws we talked about before. The pen trap and trace. So I'm sure all of you have probably seen the pictures of like when the phone systems first came up. So I would say I'm gonna call my grandmother in Springfield, and I pick up the phone, I dial the operator and say, operator, I want to call my so and so in Springfield, and she literally takes my cable from my phone and connects it over here and connects it to her in Springfield. And what the pen, this is basically what's called the pen register. So when they did that, they would write down, John called his grandmother on this particular date, and I don't know if they were recording times. So the pen register trap and trace came out to protect that information. So the government couldn't just go and get that information freely, but that information was also protected. This was updated by the Patriot Act, whenever that came out, to include more modern communication mechanisms. Not everyone uses their phone anymore. A lot of stuff happens through email. So the Patriot Act updated the pen register trap and trace to include things like to and from, IP addresses, I believe, even ports. I don't know if it extends beyond email, like you were talking about other sorts of communication mediums like peer-to-peer or Skype. I don't know if it includes anything like that. Perhaps it should, but that's probably a debate for another day. Providers, so Verizon or Google, they are exempt from this if it's done for very particular reasons, among other things, like if it's done to protect their customers and prevent abuse, there's exceptions for that. Makes you wonder, is something like caller ID illegal? Like you call me up and I have caller ID installed on my phone, like is that little single line that says you called me, is that single bit of information now protected? So what does this all mean when I'm here talking about this stuff? So we've talked about some of the, I've defined what I mean by security research. I've talked about the players in the space. I've done an okay job of describing the laws they're trying to put online. So what does this ultimately mean for the players in the space? So how about, what does this mean for the vendors? I don't really think vendors are in a better spot because of the law at all. I mean, if you talk, just a couple big bullet points here. Secure development. I don't believe there's any law that necessarily says a vendor must have security integrated as part of SDLC. I've been at companies where I've attempted to integrate security with SDLC, and it's really hard because security is a cost center rather than cash cow. Security is kind of like insurance. There's a great anyone like a comment here about Chris Rock. So a skit by Chris Rock where he gets up there and he talks about insurance and basically calls it in case shit. Like in case stuff goes wrong, you buy insurance, it doesn't do you any good until you need it. Same thing with security. Security doesn't make you any money until it prevents you from losing. But plenty of companies have demonstrated that when security is part of the SDLC, it works well. I am an anti-Microsoft person. One of the staunchest you'll ever find. But actually, I think Microsoft is a good example of when security is integrated in the SDLC. It actually works fairly well. I saw a presentation not too long ago where someone graphed the number of vulnerabilities. I think it may have even just been Internet Explorer since Microsoft really started taking security seriously and integrated into their life cycle. And it was basically plummeting. Like when it first came out, the chart was off the charts, and over time it's been going down. Are they perfect? No, but at the same time, it's a huge company. They have really big, complicated products that have been around for a long time. Furthermore, excluding things like PCI and HIPAA, There's really few regulations that say you must do security development at all. So how about vulnerability disclosures of the active? So you're a vendor, you have products or services, and there's a vulnerability that comes up. Are you obligated to disclose? I don't think there's anything on the books that says you must disclose that you did something wrong. So there's zero obligation for companies to be reporting these vulnerabilities in the first place. There's either no or negligible financial impact when the company does have vulnerabilities and they publish it. Again, I saw a talk, I believe this was at, I think this was BSides Las Vegas just this past summer, where someone did an analysis of companies that have had, kind of major security vulnerabilities in their products, and what do those vulnerabilities ultimately do to their stock price. I think what they found is that the stock price does dip a little bit, but it's not like it just plummets and goes to the floor and never comes back again, and that company disappears. It dips a little bit, and it comes back, and no one's the wiser. It doesn't really impact anyone at all. So if you have vulnerabilities in your products and you publish it, doesn't, not necessarily a bad thing from a financial perspective. From a PR perspective, sure, it could be a total shitstorm, pardon my French, but it can be a big thing. If you were in the keynote, the panel earlier with the DA and FBI, Secret Service, there was a gentleman from USC, I believe he was from, and he was talking, so he's in the private sector, and he said, basically, no way, I don't want to tell anyone about these vulnerabilities, because that's really bad for my image. I can totally understand that. When companies do disclose the fact that they have vulnerabilities, the detail is really all over the map. I got an email earlier from VMware, I'm not picking on VMware, I just happened to see it, so it's fresh in my mind. The vulnerability disclosure that they sent out basically said, an undisclosed vulnerability can allow information disclosure. It's like a very, really high CVSS score too. Just like, is that useful at all? And in my opinion, is no. But then so you have companies like VMware, Cisco, and Oracle. I think are also guilty of this, like very low detail. Then you have companies on the other side of the spectrum, like I think Microsoft is probably a good example. The detail in their vulnerability disclosures is actually useful. So me as a researcher or a customer potentially needing to patch these products, I can make more informed decisions. So another thing that I kind of glossed over with regards to vulnerability disclosure, it's not just the act of disclosing the fact that you have a vulnerability. It's also the act of interacting with the public, and taking in vulnerability reports from your customers or independent third parties. Unfortunately, that process of working with external parties to hear about these vulnerabilities and get them fixed is very, very expensive. It's expensive and it's not easy. And again, it's not really making you any money by working with third parties. So how about compromise and breach notification? I think there probably are some exceptions here, maybe PCI and HIPAA or something like SOX. As far as I know, there's no legal obligation for you to disclose when you as a vendor get compromised. I mean, things, like I said, things are probably different for PCI. That's why companies like Home Depot, when they get around their target, they come out and say, yeah, we have it, or we had a disclosure. Is there a financial impact? I would like to think so, but I don't know if anyone's done any research on when a company is ultimately, if they are compromised as opposed to having a vulnerability in a product that they sell. I don't know if anyone's done any research, but I would imagine that it's similar. It's probably a much sharper dip in terms of stock price, but I imagine it kind of bounces right back unless the company just completely goes out of business and says, you know what, we got going so bad, we're just done with this. Mic drops and walks out. But similarly, on the compromise and breach notification, the detail is it's not very useful. I mean, the Home Depot thing, what happened last week or the week before, and I think they just came out and said, oh, they've been in there since April. The amount of detail that comes out in these compromise reports is very, very minimal. The exception is the Verizon breach report, which some of you have probably read before. The detail that comes out of those is much more helpful, but when's the last time you saw a vendor say, we were compromised, and here's how it happened?
There's two states that require for PII, which are Massachusetts and California, but it has to be a very specific combination. So it has to be like first name, last name, plus another identifier, and only if those combinations are breached, then there's disclosure for it. So if you're a vendor and you only store email addresses, you don't store that information, from a legal standpoint, it's not a breach.
Another thing that happened at BSides Las Vegas this last year, there was, I believe, pretty sure it was Bit9, so someone can correct me if I'm wrong here, but Bit9 was so Bit9 is a player in the security space, and they were compromised. Bit9 did something that I totally didn't expect, and they got a lot of respect, presumably at Black Hat, but also at BSides. The CEO or CTO basically came out with a full blog post, full details on what happened. And some people who are on the operations side may be cringing at the thought of writing, A, disclosing the fact that they were compromised, and B, giving out all the details. But in reality, that sort of stuff is super useful to the community at large. So really, for vendors, there's really no obligation for them to be playing nice from a kind of research and security knowledge-based perspective. How about the consumer? This should be fairly straightforward. So beyond public shaming, trash talking them on Twitter or sending nasty emails to them, you really have no, you as a consumer potentially have very little recourse aside from taking your money elsewhere. PCI and HIPAA are good starts, but if you think about it, those really only protect you as a customer, like when you're using a service where you're like going to the hospital and giving your information, or you're going to a website and purchasing something. It really only helps you from a service perspective, not necessarily from a product perspective, something you go out and buy or software you install in your system. You don't really have much, very much recourse there. So unfortunately, you're often stuck with products that are just horrible from a security perspective.
The FTC's gone after a couple vendors. The FTC went after TrendNet, I think, for their crappy solo routers.
It's Foscam.
Yeah.
It's the
So yeah, the consumer can't do anything. I don't want to contradict you. I just think like that there at least there seems to be some precedent that the government can at least hold companies accountable. Like, there's some incentive to do it right, so that you don't end up on the wrong end of FTC.
Unfortunately, from conversations, and I had some direct conversations with the head of FTC at DEFCON, it was as long as you're swimming faster than your other competitors, which is a very hard thing to present as a protection.
Yeah.
You don't have to be the fastest swimmer, but you have to be better than the worst company, which is not a security policy to live by.
What's that saying about like when you get chased by a bear? You don't have to be faster than the bear, you just have to be faster than the bear that's faster than the guy that's with you.
Yeah.
That's all that really matters. And one of the things that just really I face palm every time I hear when a company gets compromised or they have a problem. What do they usually do because of it? They give you free credit monitoring. Like, thanks, I already have credit monitoring. You don't really need that. Oh, it's for life. Okay, thanks. What's that worth? Like a couple $100. It's not really all that useful. I mean, props to them for trying, but credit monitoring, that doesn't really help after my home network is compromised or someone stole my credit card and is hiring prostitutes in Ukraine. That's not very helpful to me. So what about the impact on the researcher? Unfortunately, there's more from my perspective, especially when I've done independent research in the past prior to Rapid7 without the kind of legal representation. There's far more negatives than there are positives. So the positives, I can only think of two, kind of fame and fortune. I mean, there's a lot of money to be made in doing security research, bug bounties and stuff. I know plenty of people that make all of their income on bug bounties. You can make hundreds of thousands of dollars per year just finding vulnerabilities in things that are big name products like browsers and stuff like that. You can make serious money doing that. There's also the fame, going to conferences, presenting white papers, all stuff like that. Some people really enjoy that sort of stuff. But in terms of the negatives, working with vendors to attempt to disclose vulnerabilities, it's a real pain. I mean, has anyone here ever done security research and tried to work with a third party, work with a vendor to get that stuff disclosed? I see a couple hands. What was your experience there?
I've been on both sides of it. I'm a vendor, and I have to help field vulnerability reports, which I think leads to a much better response from the researchers reporting to us, because I've been on the other end as well. I mean, it used to always be entirely awful, and now in 2014, like 10% of companies sort of kind of get it, right? I mean, it's not a pleasant. It is getting better. I think these bug bounty guys that are running, commercially running that as a service for smaller vendors and things, have really raised the game of vendors' response, because they're willing. They in their sales pitch, they're going in and telling them that all these things that you're doing that are wrong are making you look like turds.
So to summarize, try, like especially from me and the researcher trying to work with companies and help them fix the vulnerabilities that I find, it's really, really difficult. Oftentimes they say, well, let me get you to the next level of support, or do you have a support contract in the first place? Then they might not even want to talk to you if you don't have a support contract. And the end result oftentimes is that research just kind of falls in dead ears and might just get swept under the rug and no one ever hears about it again. Or you get people that say, you know what, you want to play that game, I'm going to go with full disclosure route. And if you read a lot of the mailing, especially the full disclosure mailing list, you'll see this stuff not on a daily basis so much anymore, but previously it was like on a daily basis. There was 0 day, all of these mailing lists, and it's because companies are not willing, either not willing or not capable of working with researchers who generally have good intentions at heart. And then, not surprisingly, one of the biggest negatives are all these laws. I mean, these are serious laws. A number of people, some of our researchers at Rapid7 have been targeted several times by these laws. We're out there trying to do the good deed, and then companies come after us. So these are real. These laws aren't just things written on paper and they only apply to like truth and bad guys that are really out there trying to steal credit cards. Even if you're out there and playing, you think you're playing along the ice trying to participate in the greater good, these laws are out there and you have to be very aware of them. So, what is the legal impact here? Again, with my fonts kind of getting magically large. If you think about my perspective on the laws, it's kind of ultimately a response to a stimulus. The law, the Wiretap Act originally came out in 1968. It's not that they thought they needed the law to prevent something in the future. The wiretapping was already happening. So the law comes along after the fact and tries to keep people in line. So really the law is kind of last in line in an arms race. They're really constantly trying to keep up. The terminology, so this picture, right, you can see that there. It's my colleague Trey Ford, who's originally going to be giving a presentation like this. So 2 books on his desk, and I believe the one on the left is all about legal terminology. So that dictionary is probably bigger than most English dictionaries. That's just specifically for law terms. So the terminology in all these laws, they seem very open to interpretation. So us as potentially technical people, you can read things like authorized or protected computer or things like that, and it may mean one very particular thing to us, but in the eyes of the law, it's a totally different thing. And that's where you can really get into trouble. It makes me wonder, can a balance be achieved? Is there a way for laws to be written or rewritten, as the case may be, such that the bad guys are still kept at bay, but the people out there, like myself, who are trying to do good things, can actually play along and not face constant scrutiny. So really, here's the problem I'm trying to get at. I'm wrapping up shortly here. So really, vendors are out there potentially not wanting to play along, saying security, in a sense, saying security research is damaging or it's expensive. Consumers are saying the products you're selling here are insecure. I'm getting every time I go shop at a new place with my credit card. 4 weeks later, it gets compromised, and I get more kind of monitoring. Consumers are potentially not just as happy from a security perspective as they should be. Researchers like myself are saying there's a lot of problems out there. When you scan the public internet, you would be amazed at the sort of stuff you see out there. So it blows my mind every time I do research there. We are here to help, but really, like from an independent perspective, there's very little you can do without really skirting the law. And the law, I don't even know what to say from a legal perspective. The law is trying. I mean, the panel, when the panel spoke earlier, I was really inspired. It's great to see the local resources, FBI, Secret Service, wanting to reach out. And when, I forget his name, the gentleman from the Secret Service who said, call me up and I'll come to your company and give you certification. That's kind of a totally different perspective that I had when I was writing this presentation. But I still, and I think they kind of admitted that they're trying, but they don't necessarily have all the resources. There's plenty of room for improvement there. So are we in a bit of a stalemate here? That's kind of the question I'm posing. The law potentially can't really keep pace. I feel like the bad guys are winning in some respects. These compromises are still happening. Vendors are still having security problems. Things are they getting better overall? Yeah, maybe, but potentially not at the rate that they could or should be. Unfortunately, 2D researchers, especially the independent researchers, college kids without the benefit of like legal or corporate representation, are basically being scared off. They're not able to do research, and they might be truly interested. And then existing researchers are stifled. So maybe back 10 years ago when you were doing security research, you could scan the internet, you could do whatever you wanted, it'd probably be okay. But I think it's a totally different landscape now. You got to be real careful what you're doing out there. Really, though, if you think about all of those laws, and if you actually want to play nice with the laws, the pressure is on you as a researcher to understand and respect the law. There's really nothing in the law that say a vendor must have secure products or vendors must work with third parties. Basically, the laws are designed to prevent the bad guys, but they're also really stifling the good guys out there as well. I mentioned lastly that vendors can and have tried legal action, and unfortunately it hasn't worked in cases. So what's the solution? This is a Vanilla Ice reference, if no one gets it. Stop, collaborate, and listen. No one? Come on. So I think that the solution I'm proposing here is something that I feel like this was staged, but it really wasn't. So when the FBI and Secret Service guys were here earlier, they were saying, like, we'd like to talk to you, you want to talk to us. It really jives with what I have to say here. So I think if we all participate and collaborate, we can really make some true inroads to allowing security research to advance, but while also keeping aware of the law. So how about some suggestions for the vendors? This particular quote, those who don't know history are destined to repeat it. There's actually a number of different variants of people throughout history that have used that. But what I'm getting at here is something that Adam Shostak gave at a recent presentation, and that's basically, vendors we're kind of all in this together. And yeah, there's competition between vendors to gain market share and customers, but really from a security perspective, we're all kind of in the same boat. So if you as a vendor have you have a compromise, you have a security problem, consider not just like keeping it to yourself and burying it like in your internal bug databases or anything like that. Consider publishing it. Consider coming to forums like this and talking about the things you had, because other vendors are out there that haven't had the misfortune to experience of that problem, and then learn from it and potentially avoid that mistake in the first place. Adopt a strategy that encourages research. It encourages security research. That can really mean any number of things, but primarily I'm talking about finding a way to work with external parties that want to help make your products more secure. So that could eventually mean you standing up your own bug bounty program internally. As I said before, that can be very costly. It's very costly and very difficult to do. Fortunately, there's a number of companies out there that do that sort of stuff for you. The two big ones that I know of, BugCrowd, and I think they're based out of San Francisco, and HackerOne. Both exist and can run your bug bounty programs for you, either for free of charge or for some fee. I believe there are others as well. Anyone know of any other bug bounty programs out there besides?
They're free, but you can offer actual bug bounties if you want to people who do the research for you.
And these bug bounties are they're no laughing matter either. You're talking about thousands and thousands of dollars of money potentially available to researchers who are out there trying to do the good stuff. Participate in the security community. So if you're a vendor and you're here, you've kind of taken that step. You're here, you're listening, you're participating in the security community. If at all possible, try and participate in the legislative process. And your vote really does count. I mean, I hate to say that, but it really does count. If you have the ability to influence legislation in any way as it relates to security research, by all means, use your vote. Consumer suggestions, demand secure products in any way possible. If you have contacts at vendors, use them. Vote with your money. I mean, I realize you might not have that option, but if you do, you should start voting with your money. Potentially, vendors who don't adopt a practice that allows secure products to be released to the public, and they start losing market share, potentially they'll start learning from that. Similarly, participate in the legislative process. Your vote really does count. Researcher suggestions. Actually, do we have any? I meant to ask this earlier, but do we have any actual lawyers in the room? How about people who do research as their primary role? Okay, we got a couple. So suggestions for you. This is really something that I hadn't really been super aware of before. So understand and be aware of the law. I don't mean like go get a law degree because those are expensive, take a really long time. But this kind of a cursory idea of the sorts of things that you should and should not be doing. But I don't, absolutely by all means, do not stop there. If you have the benefit of working at a company that allows to do this as part of your job, or potentially even like as a kind of extracurricular activity, make use of the legal staff that you have, or that you may have available to you. And if you don't, that's very likely that Rapid7 is the first company I've worked at where we actually had legal staff that said, A, it's good that you're doing this, and B, we're going to support you in any way we can. If you don't have that benefit, you should absolutely go up to the EFF. They're at basically every conference. It's not a joke. They exist to protect your digital rights and your freedom online. You can call them up and they will give you free legal advice, potentially point you in the right direction. I would highly encourage you to practice responsible disclosure in the first place. So don't go out there, drop it. If you're doing research and a vendor kind of gives you the cold shoulder, don't just go 0 day on them and drop on full disclosure. But similarly, encourage them to practice responsible disclosure and responsible remediation. So if you report a vulnerability to them, they're going to get it fixed. Try and find a way to get them to release some details that are useful to the technical community. Absolutely participate in the bug bounties. I mean, if nothing else, do it for the money. There's a lot of money out there, but there's also the greater good. If you bring up the HackerOne website, later on when you have safe internet access, they have bug bounties for all manner of products that you may use in your home, or you may use just as part of your daily life and not even realize it. Web servers, peer-to-peer software sharing programs, chat programs, really, the stuff that kind of forms the core of the internet that we use every day. There's bug bounties out there that exist. I don't actually know where the money comes from. I believe it's like charitable donations, but that money exists to encourage people to go research these products, find vulnerabilities, and secure them before the bad guys find these vulnerabilities. Lastly, from a research perspective, publicize and give back. This is actually my first time doing any sort of public speaking, so I'm kind of, it's a bit weird for me to be saying you should publicize and give back since this is my first time, but I would absolutely encourage you anytime you do security research, by all means come to conferences like BSides or DEF CON or wherever and talk about the sorts of things that you're doing related to security research. Legal suggestions, I just have a couple of things here. Engage industry experts, and so don't just hang out with your law buddies and talk about the law and attempt to make it good, to protect our online rights and protect digital communication and stuff. That chances are things are going to go really poorly if you do that. So find industry experts, find people that truly understand the technology and might have some understanding of law, and work with them to come up with laws that both protect us and the stuff that we care about from the bad guys, but also doesn't stifle the good stuff that happens online. So not surprisingly, find a common language. Potentially consider not using words like authorize or these very ambiguous words that we talked about earlier. I wish there was a way that we could start penalizing companies for releasing insecure software. You had two of you were mentioning that earlier that a couple of companies have faced legal action and fines for having the insecure products. But I really wish there was a way for the law to basically coerce or encourage companies to not have problems like this in the first place. And lastly, keep these things up to date. Just look at the timelines that I mentioned briefly earlier. The law was originally, the Wiretap Act originally came out in 1968, was updated in 1986, so almost 20 years later than the Patriot Act. And technology moves pretty quickly. We need to find a way to get the law to kind of keep pace with, not necessarily keep pace, but at least not lag super far behind. So conclusions and stuff. I believe we're almost exactly on time. So the law is perhaps not as effective as it should be, and by that I don't necessarily mean it's not strict enough and it's allowing bad guys to do bad things. I mean that it's not finding the right balance. It's not allowing the security research to continue. Unfortunately, research is being stifled. There are voices that are out there trying to do the good thing that are just being silenced. I think you'd be hard-pressed to find anyone that would say that security research is bad, and a number of my colleagues have kind of done some informal surveys and found that there are people out there, legal representation, corporations really want to see the security research continue and help everyone drive towards the greater good. This can't succeed. You look at these bug bounty programs truly are successful. We need to keep this moving. From my point of view, the research that I do and I do as part of Rapid7 Labs, it's absolutely going to continue. The law is out there. It's serious. We have to be aware of it. But I'm not going to shy away from doing some research. That's what I love. And I think that there's a lot of good stuff that comes from it. Last and absolutely not least, I have to mention this. My colleague Trey Ford and a couple other folks at Rapid7 are working with lawyers, legislators, and corporations, and finding a way to allow security research to continue in a way that doesn't get people in legal hot water. That particular mission is called the Coalition for Security Research. C4SR, there's a website that's up there. If you're interested, you can go there. It's a very brief summary of what's going on. There's a white paper you can download to find out more. And I believe that's it. So thank you for coming. I believe we're over time, but no one's knocking down the door. So if anyone has any questions, I'll take them now, or you can reach me there.
I'll throw two things out. There's I'm on both the security research side and the manufacturer side. So there's those of us that are trying to bridge the gap between security researchers and manufacturers who may not have the financial ability to build security teams. So there's a group called I'm the Cavalry, and there's another one called Build It Securely. And we basically work together. So I work for Vulcan and Linksys, but we actually send out free product to researchers. They get the benefit of free product to do research on that gets them, promotion to their jobs. They get, it costs us $1,000 per product, which is nothing, and we get additional research out. So there's a bunch of us trying to get smaller manufacturers who don't have that capability and the right security out. And also doing kind of the same thing of trying to make sure they understand how to present that security information and research without getting arrested. Anything else?
Okay, if not, you can reach me there. Just my email address and my Twitter handle.
If you want, you can help the product.
Oh, yeah.
Anyone has questions on the cost from the
Speak with the nation, right? Yeah, but it's a huge thing. Take your boss. All the cops that say someone stole my purse. So you get logged on your computer and you're ashamed. Crazy people think I'm stupid. Like there's this whole form and I think professional life people. Yeah, so nobody wants to report anything. And that's why it's very much. They said something stuck with something. She didn't say anything.